Thompson?
Here now, the attorney is back for the state name.
No, sir, Mr. Thompson. You know I don't put up with any of that. You understand?
Right.
Listen to me.
Yes, sir. Go ahead.
You understand I'm not going to put up with that?
Yes, sir.
Not anything like that. You understand? Do you understand me?
Yes.
There's not going to be any private citizen, sovereign citizen, any of that. You understand?
Yes, sir.
Okay.
Before this hearing even gets underway, we're watching a legal powder keg that's seconds away from blowing. 3 cases, multiple serious felony charges, and a defendant who's already rejected a 20-year plea deal and is about to reject a 25-year one, too. The stakes? 2 potential life sentences, both of which the prosecution is clearly prepared to pursue. And what makes this case explosive is the tension simmering beneath every exchange. The defense says the client won't cooperate, the defendant claims a conspiracy, and the judge has to navigate the legal chaos without letting the entire proceeding derail. This hearing is the perfect storm of courtroom pressure, last-minute filings, accusations of misconduct, a defendant claiming he's being forced into agreements he never understood, and constitutional rights being invoked rapid-fire. Even before anyone raises their voice, you can feel the friction between the attorneys and their client, and it only escalates from here. And keep watching, because the deeper we go, the more confusing and confrontational the defendant becomes, eventually pushing this hearing into sovereign citizen territory, self-representation dangers, and a moment where the judge has no choice but to take control. This is one of those hearings where every word matters, and every misunderstanding has consequences.
You're before the court today for your affidavit of violation of probation. You filed a bunch of stuff that doesn't make any sense. I've denied most of it. I'm going to probably deny the rest of it.
Really?
Yes, sir.
All right.
Absolutely.
I got some education to go, huh?
Sir?
So I've got some education to go.
Yes, sir. You're here today by, you got a new law violation of driving my license suspended or revoked. You don't want to have an attorney appointed to represent you?
No, sir.
Are you sure?
But that's the thing is, I've never even been pulled over. I don't know how I got a license or a warrant or anything. I haven't been pulled over in more than a year. Any emergency contact. I went to go pick up a records request and they gave me a warrant instead of the records.
Do y'all know anything about this?
As to the new law.
Do you have a driver's license?
No, sir.
Don't answer that. I shouldn't ask that question.
Fair enough. Fair enough.
Strike that from the record. I won't do that if you won't do any other mess. I won't ask you that question.
Right here is the first big structural turn in the hearing, and it's subtle but important. The prosecution confirms that 2 major charges, attempted first-degree murder and witness tampering, are officially consolidated for trial. Consolidation means the jury will hear both cases together, which seriously increases the pressure on the defendant. It also means the prosecution is confident their narrative works better as a single, unified story. Notice how the prosecutor casually mentions he left the amended information on the printer. That may sound small, but it tells you something. The case is moving fast, deadlines are tight, and everyone is preparing for trial in real time. When cases are this serious, even clerical mistakes get amplified, and it foreshadows how chaotic the rest of the hearing becomes. Keep an eye on the defense attorney, because while he's trying to maintain structure, his client is about to blow the doors off this hearing.
Right. You transfer that to?
Just filed. I just filed in the court file.
I tried to, and they wouldn't accept it.
All right. Was he arrested? Is there a new arrest for driving license suspended or revoked? State?
Yes, there was a bench warrant issued on 1/23/24 that's executed 1/29/24.
Said I was just doing a records request and had an agreed upon date to pick it up. Went up there to pick it up and gave me a warrant. So the records are requested.
I tell you what, I'm gonna let y'all
Return
do that. Listen, I'm gonna leave him on probation. I'm gonna set this for preliminary on April. What's that April date?
April 17th.
April 17th. I'm gonna let him take care of that in county court and see what happens. Okay.
Thank you.
And I think that's the only violation he had.
Yes, sir.
Keep doing what you're doing on this, and then we'll see you back in April, and you can take care of that in county court,
All
okay?
right, thank you.
Yes, sir. Sign a notice.
State your name, sir.
The beneficiary, Cedric Alexander, a human being.
Mr. Alexander, I don't accept any of that. If you want to state your name, state your name. If you don't, that's fine.
I'm Cedric Alexander, the beneficiary, sir.
No, sir, I don't, the beneficiary doesn't mean anything to me. It says, are you Cedric Alexander?
I'm a human being, Cedric Alexander, not the corporation.
What I'm be held with that.
I'm a human being, not a fictitious entity.
On your first appearance, I'm going to appoint the office of public defender. You've got a failure to appear on
Not
a,
your majesty, my public
misdemeanors.
defender.
I have ordered to be held without bond on that. I'm going to leave that as it is. You got a possession of methamphetamine and see, that might be all the same thing. Yeah. You've just got a failure to
The
appear.
officer didn't even come and do
You'll be
depositions
held
because there's a
without
lot.
bond on that. You've got to drive my license, suspended or vote. I'm gonna find there's probable cause. I'm gonna set, that's a third degree felony, punch for 5 years, Florida Department of Corrections. And a
Fictitious entity cannot drive,
$5,000.
sir.
I am going to set a $5,000 bond. I'll see you March 11th at 9 o'clock. Good luck.
Thank you, sir.
All right, go ahead.
Here's
Step
where the emotional tension spikes. This is more than legal strategy. It's about trust completely breaking down between a lawyer and his client. The defense attorney is doing something attorneys rarely enjoy, building a record showing that he did advise his client, and the client refused. This is a protective move. If the defendant later claims ineffective assistance of counsel, the court can look back and see the lawyer warned him, laid out the risks, and encouraged him to take a lighter sentence. But the defendant's stubbornness creates a huge disconnect. A 20-year mandatory minimum is a serious offer, but in attempted murder cases, it's sometimes the best deal a defendant will ever see. Rejecting it puts him on a path toward life in prison. And the defense attorney's tone isn't angry, it's resigned. He knows what's coming. The defendant is about to take this hearing somewhere no attorney wants to follow.
Hearing, you're representing yourself. You know, at any point in time, you can ask an attorney to be appointed to represent you. Do you understand?
Yes, sir.
Do you still wish to represent yourself?
Yes, sir.
Yes, sir.
All right. Mr. Loving, you can call your first witness.
All right, state calls officer Zip. Richard Zip.
Just swear the witness in.
Promise for the testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God.
I do.
Can you state your name for the record, please?
Richard Ziff,
Where are you employed?
Panel City Police Department.
Were you working in November of 2023?
I was.
On November 11th, 2023, did you have occasion to come in contact with defendant Josiah Beecham?
I was.
How did you come to come in contact with him?
It was an investigative stop. Mr. Beecham's vehicle was having a hard time maintaining its lane. I conducted a traffic stop on the vehicle. Vehicle drove over the curb. Immediately when I stopped the vehicle, I can smell marijuana coming from within the vehicle while still sitting inside my own vehicle. As I got closer to the vehicle, I can smell the marijuana getting stronger. When I made contact with Mr. Beecham in the driver's seat, I informed him the nature of the stop, also told him I smelled marijuana in the vehicle. At that point, Mr. Beecham was saying I was violating the Treaty of Florida, making other statements that he was not driving, he was traveling. And at one point, I asked him to identify himself. He refused to identify himself. He began to call 911 and requested a Bay County deputy respond to the scene because he refused to cooperate with me.
Officer Zip, at some point, based on the smell of marijuana, did you search the vehicle and Mr. Beecham's person?
I did.
During that search, did you locate anything of note, of significance?
We found trafficking amounts of controlled substances. I believe we were, one of them tested positive for cocaine. There was marijuana and we believe fentanyl.
Did you find any firearms during the search?
There was a firearm located underneath the driver's seat that Mr. Beecham was sitting on.
This moment is where the defendant's frustration erupts into the open. While the attorney calmly outlines the reality, a life sentence for attempted murder and up to 30 years for tampering, the defendant cuts in claiming his lawyer ain't even helped him. That's a red flag for the court, because when defendants express distrust in their attorney, it often signals upcoming motions to dismiss counsel or represent themselves, which is exactly what's about to happen. But behind the outburst is a deeper issue. The attorney is laying out the math of the defendant's exposure, and the defendant doesn't seem to fully grasp it. These aren't small numbers. These aren't negotiable consequences. And the attorney is desperately trying to document that he has explained all of this numerous times. This mismatch, legal reality versus the defendant's emotional perception, sets the stage for the unraveling that follows.
Did you run a criminal records check on Mr. Beecham?
We did.
Did you find out whether he had been previously convicted of any felonies?
He was on inmate release status for a felony. I believe the same charges.
No, that's all my questions at this time.
Mr. Beecham, any questions?
Yes. So did I have a passenger in the car with me at the time?
You did?
Upon you saying you smelled the smell of marijuana, did I say that I smoked hemp?
You did admit to it.
I said I smoked hemp, right?
You said you smoked marijuana.
Sir, did you have on a body cam?
I did.
And okay, thank you, Your Honor. So I said, so your body cam was on at the time, and did you get any competent basis on the traffic stop as far as like a recording of that video?
I don't have a dash cam.
You don't have a dash cam in your car?
We don't have dash cams in Panama State Police
Okay.
cars.
That's cool. And that was failing to maintain the lane. Okay, was it any other traffic on the road?
You were the only vehicle.
Okay, and how long were you behind me before you actually pulled me over?
I was behind you about 2 blocks, watched you drift over the center line several times.
Several times, drift off the line. Did you have to catch up to me? You know, I have a dash cam and rear view cam. I'm probably gonna introduce the what you call it. Did you actually have to catch up to my vehicle, or?
I did not have to catch up that much. I was right behind you.
I'm saying that the stretch of the road was we was traveling on Beach Drive. That's right.
Yes.
And you were behind me the entire stretch of Beach Drive.
No, I was behind you by Balboa.
By Balboa is when you got behind me. Okay, and so when did you notify me or the passenger about any of the drugs or gun?
Immediately.
Immediately. And what was said about the drugs or gun? What did the passenger say?
The gun was found after you were already detained. We searched the vehicle and it was underneath your seat.
Okay, and was the vehicle registered to me?
The vehicle was registered to your girlfriend.
Okay. And so where were the drugs or anything found in the vehicle?
You had drugs in your pocket. And there was also drugs in the back seat behind your seat.
And you found the drugs?
I found a bag of white substance in your right front pocket.
What about any vehicles in the car?
There was a bag in behind the driver's seat that had several other bags that were wrapped in a clear plastic baggies that was behind your seat.
Okay, and so what did you question the passenger on?
That would be my partners who questioned the passenger. I questioned you.
Yes, and what did I admit to any of the drugs?
You refused to talk to me other than saying I was violating the Treaty of Florida.
Exactly. And so you notified me on drugs being found in the car on the scene, you're saying?
Everything was notified to you. I tried reading you implied consent. You refused to actually listen to me. You kept on saying I was violating the Treaty of Florida and you.
Yeah, I was saying you was violating the constitutional rights as well of unreasonable search and seizure.
This is where the floor drops out. Once the state withdraws a plea offer, it almost never comes back, and the defense knows it. The attorney is also signaling to the court that he cannot ethically negotiate any further when the defendant refuses to cooperate or listen. Meanwhile, the prosecutor escalates things dramatically with the habitual offender notice, turning the tampering charge into a potential life sentence as well. Suddenly, the defendant is facing 2 possible life terms. And you can feel the courtroom shift. Even the judge pauses to make sure the defendant truly hears the words being spoken. 2 life sentences. This
I never really got a direct quote on why you actually stopped the vehicle.
His all body came out.
Okay. And so you never had a conversation with the passenger.
I was mostly talking to you and searching the vehicle. I believe my sergeants wanted to talk to Mr. Wheeler.
Okay. And so you saying your passengers, your other one of your partners found the drugs that was actually in the car?
And I found drugs in the vehicle.
Or you found the drugs in the vehicle?
Yes.
Behind the driver's seat, you're saying?
And the objection. Ask your next question.
Okay. And you did already admit that I said I admitted to smoking hemp. Okay. And your vehicle is not, you say they don't got dash cams. Okay. So at the time, did you have a sight on the passenger and the driver the whole time?
I was right there behind the A pillar or B pillar.
What was that, sir?
I was there the entire time with talking to you.
No, okay. So when you extracted me out the car, did you have eyes on the passenger at that time?
After I removed you from the car, I did not have eyes on the passenger, just you.
Okay, cool. And so in your report, you never wrote a ticket for the failing to maintain lanes, nor did you mention it in your affidavit of complaint.
It's going to be in my report, the narrative on the case.
Well, this was the probable cause, and this was the immediate review. So is it
Sustained. Ask a question.
okay? Is it a reason why you didn't mention it in your affidavit of complaint?
The affidavit only shows PC for why we arrested you. It doesn't state in there why I had to stop you. It just shows in there why I arrested you. And in regards to you maintaining a lane, that goes back to the DUI, which does not go on the complaint. That goes on the traffic ticket.
Well, you never mentioned anything of that nature in the ticket. So I was just wondering, is that protocol for you not to explain in the affidavit of complaint?
It's going to be in the report.
Okay, and you say you had a body camera on again, that's correct?
Sustain the objection. Ask your next question.
Okay, and so was it possible for any of the drugs to be the passenger?
It was all in your control. It was within your reach, behind your seat, and then you had drugs in your right front pocket.
I said, was it possible to be the passengers?
It could be possible, but the same drug that was in your right front pocket was also in that bag behind your seat.
What drug was in my right front pocket?
Cocaine.
And about how much was that?
You had a bag that was wrapped in your front pocket.
About how much?
I don't have the numbers on me right now. I have my report in front of me.
Okay. This is a copy of your report.
That's actually not my report. That's the affidavit complaint. My report's about 5 pages long.
Okay. And so you seized the vehicle for failing to maintain a lane. You said, was any other traffic affected by the occurrence?
You were the only one on the road. You had a failure to maintain your lane several times and you drove over the curb.
What curve, actually?
The curb I stopped you at, I believe, was on Fairland.
Okay. Your Honor, at this time, I don't have any more questions.
Okay. Is any redirect from the state?
No, Your Honor.
And the witness be excused.
Yes, Your Honor.
So you can go about your day.
Yes, sir.
Anything else from the state?
No, Your Honor.
Mr. Beecham?
Your Honor, there's no actual competent and substantial evidence in the affidavit of complaint, nor was it any ticket issued for the actual, failing to maintain a lane, so, being that it was immediately after the arrest, I don't see how he had probable cause to stop me. And I actually asked him for, the sheriff to verify that. hoping that he had a dash cam in his car.
Mr. Sullivan?
Whether a traffic ticket was issued or not is irrelevant.
Yeah, it was.
I have more find there's probable cause for the arrest, and I believe that's what I'm here today to do as far as the adversarial preliminary hearing. So I